Welcome to another edition of the Office of Special Counsel's video series on prohibited personnel practices. Please be sure to visit our website at www.osc.gov to view the full series of videos. In this video, we'll explain the prohibitions on discrimination in the workplace. So, agency officials can't discriminate against federal employees or applicants for federal employment. But who qualifies as an agency official, and how are employees and applicants protected from discrimination?
Agency officials are the managers and supervisors who have the power to make personnel decisions, like hiring applicants, rating employees' performance, and reassigning or firing employees. Now, there are two laws that make it a prohibited personnel practice for agency officials to discriminate against a person. Under these laws, OSC has the power to investigate and prosecute violations.
So the law protects people from certain types of discrimination. But what types? What are the protected categories?
The protected categories can be divided into three groups. The first group includes race, color, religion, sex, national origin, age, and handicapping condition. The second group includes marital status and political affiliation. And the third group includes conduct that does not negatively affect work performance.
While OSC has the power to investigate the types of discrimination in the first group, OSC's policy is to not investigate these claims because they can be handled by the Equal Employment Opportunity Process, or EEO, that is already established in agencies in the Equal Employment Opportunity Commission. Any exceptions made to OSC's policy usually include cases in which we have identified a widespread problem with an agency's EEO process. As to discrimination cases, OSC focuses on complaints involving discrimination for marital status, political affiliation, and conduct that does not affect work performance.
Discrimination based on marital status happens when a person is treated differently because they're married, single, or divorced. Discrimination based on a political affiliation happens when a person is treated differently because of their partisan affiliation with a political party, group, or electoral candidate. Here are a couple of case examples that involve marital status and political affiliation discrimination.
In a Federal Aviation Administration case, an employee alleged marital status discrimination when he was fired for unsatisfactory performance. The employee was single and alleged that management overlooked more errors of married employees and gave married employees preferential treatment regarding performance briefings and shift assignments. In a Department of Commerce case, OSC requested that the agency put a hold on firing an employee because there were reasonable grounds to believe that the action was based on the employee's affiliation with the Republican Party and not on the employee's performance, as the agency claimed. In taking this action, OSC considered management officials' statements disparaging people who support right-wing ideas and beliefs.
What about conduct that doesn't affect work performance? What kind of conduct is or isn't protected?
Well, the intent of this law is to prohibit discrimination for non-job-related conduct, meaning conduct that has no bearing on a person's job, which may occur while an employee is on or off duty.
Examples of protected conduct include an employee's participation in certain organizations, such as National Organization for Women or the National Rifle Association, an employee's outside interests, such as hunting or animal rights work, or an employee's stance on issues that may appear political, but differ from political affiliation in that the discrimination does not have to be linked to a particular political party.
There is, however, non-job-related conduct that is not protected, such as criminal conduct. An agency can consider a person's criminal conviction in deciding whether the person is suitable or fit for employment. And even if the conduct is not criminal, it is not protected if it affects work performance, like if it negatively affects the agency's trust and confidence in the employee's performance, it disrupts the workforce, or it has a harmful impact on the agency's mission. Here are a couple of case examples that involve conduct that is not protected.
In a Department of Justice case, the agency disciplined an employee for videotaping his private encounters with romantic partners without their consent because knowledge of the employee's conduct affected coworkers' work performance and management trust. In a Department of Housing and Urban Development case, the agency disciplined an appraiser's off-duty actions as a manager of deteriorated rental properties because the conduct was inconsistent with the agency's mission and undermined confidence in the employee.
In conclusion, the laws against discrimination in the workplace ensure that all federal employees and applicants receive fair and equitable treatment while balancing the need for an efficient and respectable federal workforce. For more information about the prohibited personnel practices that cover discrimination, please access the other resources on our website.